Hello, hello, hello. This is Mohammed Shilon coming to you now um, well, from this great state of North Carolina. Today is November 2nd, 2025. With me today in the presentation, as usual, is my co-host, Mr. Victor Mengot from Surrey, England. And this program is being broadcast or produced from Canada. So we welcome you again. We their audience, or with their dedicated audience, and we hope, as usual, we're going to make the necessary suggestions, contributions, comments that helps all of us. At the end of the program, we will all go learn from each other certain things more in adding to knowledge than we had before the program starts, because now we intention nowadays. Let we all try to inform and educate yourself. And some comments might come as critical to the government. We want the government to accept it. This is being done in good spirit, not for purposes of criticizing, now purposes of trying to enhance. Since we notice the process, they're not to reach the necessary experts in certain and dissolution or resolution, not dissolution of people. Then, if we tap on the ideas of people who are experts, who have the experience in being put on committees, so some of the issues then they may be better solved. And there are people who work for the UN, for international agencies like Mr. Mengot, and other people who will come with show, like a Dr. Labor on Kush. We just sometimes when we come up with any ideas and they would suggest certain people, we would try to urge the government not for just put people on committees for the sake of it. Let we get the people that will get the know-how. We go come up with solutions to problems. So we want if government officials are listening, we've always invited them for two reasons. One, let them expound or expand on which he would say. And then if suggestions or statements are made that seem to be erroneous, what we are saying in good faith. We think that the government get a duty for we open invitation that we always put out. We don't need time. If the government can call we on a Sunday morning and say, want to appear, I mean a minister of this or permanent secretary want to appear on a shoot today, they are quite welcome. We'll cancel other things because we want them feedback, we want their input in there. But we're getting none of it. So whatever critical statement we make, we make them in good faith because we think we're saying the right thing based upon the information at hand or in hand. So that said, without going further, I want for make listen to me co-host, Mr. Mengot, and he will tell you now which is the program for today, and we will move from there. So to you, Mr. Mengot. Oh, let me remind the public. Let me remind them the show as of this moment. I was just going to say we started early, an hour early, but for make any difference to the people, to the audience, because for affect Sierra Leone or people listening from many other countries. I think everything will seem to stay the same. So sorry for the interruption, Mr. Mengot.
Yes. I say thank you very much for this program. We'll get numbers them way in a king call. And today, waiting at the important thing that we want to talk about. Now, this continuation of this very important issues them, we deal with the constitutional amendment and the constitutional reforms. And in continuation of the previous programs them, we want to bring some issue them because the recommendations in this Tripartite Report, why would they insist on now? because na 80 recommendations na dem dey na that report. This week, we been see say government be don go, or the Attorney General be dey prepare for carry a document go Parliament for tell we say they don't do some amendment. But is this the right procedure? Is it what the recommendation dey about? Now make sure go look at recommendation 80, and also go make family know how the procedure and processes to be followed. Because this is a thing of national interest. Because when they talk about constitutional review, we will refer to the constitution, how you review constitution, things to deal with entrenched clauses, and we'll explain what's in an entrenched clause and non-entrenched clauses. Then the second part, now this business with the mining companies here. Recently, we've been get one program where we talk about the mining companies them and how government they sign the agreement here. What's in the legal basis of the agreement here? And if the mining companies they not they do what they're supposed to do, would have hold them to account. And we also get for look at the role of Parliament as per the Constitution in terms of how we sign all agreement, not just mining, agreement that we don't relate to things like the toll road, agreement that don't relate to the airport construction, agreement that we don't relate to mines and minerals, agreement that we don't relate to fisheries. We don't get the Black Johnson issue. We don't get so many. So is it the way to do? And then we go hear everything the speaker said they say. And we go see, is that the role of the speaker? Because it look like say the speaker every week, it kind of the headline. I will say thanks to Black TV, when our partner, we're able to give them punchline here from Parliament. So let's start first with the first problem we want to talk about. Let's look at this tripartite, two-sided and day now. We know say the Attorney General or the government side, we go present a document to Parliament. Meet the committee room 1. Then cancel that meeting there. But on the 30th, when a Thursday, the Attorney General consult with the political party them on the tripartite elective proposals. So let's start first with the last recommendation, and I want to explain to Pambulem what he say. I go pause here. I don't know if my co-host one go, because I want to go straight to this idea of them processes here, procedures for take place in Parliament as per parliamentary procedures and the recommendation that the Tripartite Report.
Now, you can proceed, Mr. Mengo. That's fine.
Okay. Let me start with, interestingly enough, the last recommendation na the Tripartite Report. Recommendation 80. Wetin down they say? It say then for check this whole thing. Recommendation 80, what it say? It say the final report, because we know say the 3 people let me meet. We'll talk about Tripartite to talk the SLPP representative with the international observers and committee. Initially, wouldn't have been them people that are waiting at the international observer. Now go back to them. Because the first meeting with them in get, now almost 1 year ago, when I been Wednesday, the 16th of October 2024. And the people that are waiting at that third arm then at the ECOWAS Commission, the United Nations Office for West Africa and the Sahel, and also we been get people then from the Africa Union when they meet for monitor waiting they happen. So if we go to recommendation 80 of the Tripartite Report, let's read it in English. It said the final report, when that report, they will get the 80 recommendations. But it's the recommendation are more than 80. It's 84 because you get 80 when now the one where the two parties then agree, then 4 when are contentious issues. When then they be mixed up before they agree the report, they may say let them add to the report rather than the main report. But recommendation 80 when are the last recommendation, they said the final report will be tabled in cabinet, and the cabinet will develop a cabinet paper to guide government of the implementation, including legislative reform. So what I'm saying here, as required. And then, interestingly enough, the parties to this agreement, when they talk parties, the two sides, then say that they call on the development partners or other international organizations to provide technical and financial assistance for the implementation. Dependency, we they ask with people them for provide technical and financial consideration. And the United States government will give 1.6 million. So waiting them if I don't do, it don't take over now. Then if I don't develop this cabinet paper, when I white paper, with that white paper, then I don't go parliament, and I go show the steps them and the structures them where they get for use for do the implementation. But it seems as if then they do on the other way around. So I tell people, I want to go to the constitution now because me I like make reference and talk about what thing and say about white paper. Okay. In Sierra Leone, the parliamentary procedure, how will they handle this white paper? In England, white paper now a document where they precede an act of parliament or an amendment of an act. So the white paper, they'll present it to parliament by either the relevant ministry. In this case, the Attorney General and Minister of Justice. Because it's for come from the presidency. So, now that they'll do, when they don't present it to parliament, then that will be the debate. When they talk, say, some of the changes them, you get entrenched clauses. What do they mean by entrenched clause? Entrenched clause is a thing where and I'll go through that at a later part. Let me give you an example. One of the things that we've been talked the last time, now for allow the criteria for stand as a presidential candidate. If you are down there, where they say only somebody where you get for doing to a party now, if you want to bring independent, then an entrenched clause. You know, go change them without a constitutional amendment where refer to a referendum. The other one, them now, you say you can do unto constitutional instruments. Now, the one they now they say they don't draft. But since they get a paper, they don't ever go to parliament. Parliament just stop abruptly. Because not to the amendments, the law, legal amendments, they for care go parliament. They for care what we call the roadmap, right? Waiting and they consider the institutional reforms then. Because reforms with the electoral management system, reforms with the security systems them, the security people them like the police, the Office of National Security, how they for be independent, how for provide support for political parties, and also things to do with the electoral management system, voter registration, no qualification for two when I recommendation 78, we talk about PR and first past the post. So now that for do then we not do that in the 8th. So the committee, the white paper, when they can't go to the committee, they can go to the legislative committee or the constitutional review committee. Because the committee then But this time, this paper where them in Kergo, then say, now a pre-legislative committee them in can go for. So the procedure, now in their challenge. But then also, because now a white paper for deal with constitutional and legal amendment, the parliament therefore invite the public for make submission during the hearing or engage in consultation. So it seems as if, on the one hand, they don't draft all NTR, they want to go parliament, then they say they still do constitutional consultation. So these are the problem we'll get. So let's stop there. Let's see what in a view on what I explain so far.
Okay, let me ask you, because it seems like not only the government does skip certain steps in the process of doing the referendum, or whatever they try to do for the constitutional review, but it looks like they have not only skipped, but they also they do them in the reverse, because if according to my understanding, this is something that should have been brought before Parliament, and then a Parliament, it seems, based on your understanding of what you're saying, now Parliament get the responsibility of inviting the public for participating or to a hearing. But now and correct me if I'm wrong again, but what I understand you saying, the government itself is playing the role that Parliament should be playing, in that now the government, the AG, the Attorney General's office, they don't make up their mind, they don't agree for the public, then they just go through the motion of calling what you may call consultation, whatever that means, and then say, well, now this would not reach, now this is not the reason, and they will check and go Parliament on such and such a day or such and such date. Whereas it should have been taken to Parliament first, then Parliament, and then forget the public involved. Then we'll talk about this white paper now. So please, sir, I just want, for purposes of the public understanding the steps and the way I analyze them, if I'm right in saying it has been a reverse way of making the presentation is being done here, or even if it's going in the proper form, that they don't skip certain steps. Am I right?
Okay, let's go back to this agreement almost a year ago. Yeah, in 2024. And then if you go back to recommendation 80, because you get 80 recommendation, let's go back and remind you what recommendation 80 say, because we forget them in the context, let not be so the misquote government. Because recommendation 80 said the final report be tabled in cabinet, which they have done. And that cabinet develops a cabinet paper to guide government of the government of Sierra Leone in the implementation, including legislative reform as required. So in other words, rather than go now with detailed amendments, where then they tell we say they don't draft over 40 laws then, right? They should have gone to Parliament first and say, okay, these are the recommendations. And the recommendations, they are threefold. You get some where it relates directly to amendment of the Public Elections Act. And what's in the Public Elections Act they deal with? It deal with issues for deal with the ECSL, the Electoral Commission of Sierra Leone, the mandate, the organization, who they run them, how then they deal with voter registry, how then they deal with candidates we will apply, how they approve them. So the whole electoral management system is one part of that, the report. Then you get also in the report, you get certain things that we can change. It get for be constitutional amendment. And even the electoral laws them, the Public Elections Act, then get the authenticity through certain sections of the Constitution. So even if they amend the Act, you therefore equally amend the Constitution. And when they amend the Constitution as well, you get recommendations. So what I think they would have done in that white paper, then for let we know, say, these are the recommendations we deal with entrenched clauses, which means we cannot change them unless we go to a referendum. These are the ones which relate to amending the electoral laws, then Public Election Act, amending other acts like the Political Parties Regulatory Act, right? Then you get other one them. Now that same document there is new things them, where some of them want and they now want put forward. Because then they talk about new legislation. We be not get the GIWI, Gender and Women Empowerment. If you go to recommendation 52 now, then they talk so forget another act for youth development. We say, then they propose say 10% of elective, and let me read them because I not elect for I want go straight to recommendation 51. It say clearly where they talk about the youth sim. And then in a critical issue, let me read them what it say. It say adopt a National Youth Development Act similar to the GIWI Act to provide for at least 10% of the members in elective and appointed bodies to be the youth using the African of up to 35 years old. So then they go require section 58 of the Public Amendment Elections Act for be amended for reflect this. For the appointment to public office made by persons other than the president, at least 10%. Even that, if we look and say, it will be an entrenched clause. Because when it's the way they change for shift the balance, because get laws the way they talk about equal opportunities or all that thing in there. So coming to us and say we go amend, then consider a referendum, then later on we go consider the one that we need a referendum, and the Attorney General tell we say then they go mean say we go draft new constitution for going to a referendum. And if them not promise we say they go do this thing during this term of office, we are now end of 2025. So by the time you go 2026, you also will have to develop a referendum. First of all, amend the constitution, bring the new constitution, and get a bill. We then also Parliament therefore review and approve. And if you want, I can go through the constitution with that. So the whole thing is a mismatch. It's like half a dozen of one and 6 of the other. So that is my concern. You know, let's play one video where one of the opposition MP, what he say, another critical now then they raise them. If we can get a control room for play, and this now, I think, say a response after the president's speech. Let us listen to this video, then I will make you analyze all which I don't talk so.
Mr. Speaker, honorable members, I want to draw your attention to an issue that sits at the very heart of our democratic stability, the implementation of the confidence-building measures around electoral reforms. Mr. Speaker, honorable members, we've heard from the President, but so far we have not seen visible time-bound actions. Mr. Speaker, for too long, every electoral cycle begins with mistrust, accusations, protests, and last-minute reforms that erode public confidence. Mr. Speaker, honorable members, this House must not be a bystander. We are continually charged to safeguard democratic integrity. Hence, I proposed, Mr. Speaker, honorable members, recommendation 20 of the Tripartite Committee. It reads, to create a dedicated oversight committee in Parliament comprising representatives from all political parties represented in Parliament as a standing committee on electoral matters to review an electoral cycle required into electoral preparedness and guide legislative reforms. The committee should be chaired by an MP from an opposition. I want to urge this House to speedily constitute this committee, Mr. Speaker.
Yes, sir. So you don't read this one. You remember the recommendation where he actually mentioned. That's recommendation 20, where say create a dedicated oversight committee in Parliament comprising representatives of all political parties as a standing committee on electoral matters, review the electoral cycle, and inquire into electoral guidance. So why am I quoting this one? I'm quoting this one because this one only legislative reform. So in my own view, recommendation 20 and recommendation 80, now then for don't take precedent. Because recommendation 20, Parliament, so that this white paper where government for don't do, we don't long overdue, for going to that standing committee, they look and force, then Parliament debate them before they go begin draft laws. That is my argument.
Along that, I'm also the clarification that I was seeking from you was they haven't done what you just stated. Now the Attorney General, who should not be playing such major role in all them proposed changes here, is out there talking to various bodies about having met some of the recommendation or proposed recommendations by the Tripartite Committee, and trying for just a few remaining recommendations have not been dealt with. So again, going back to the question that I am asking, well, I'm putting it in the form of a question, but as I understand it, the recommendation 20, recommendation 80, all of which, entrenched clauses, non-entrenched clauses, the process, if I hear it right, is the same. They should be presented to Parliament, they should be part of the white paper, which should be presented in Parliament, and things will be taken from there further, not at the current process where they go, without it having been presented. The Attorney General is going around. Well, first of all, is the role the Attorney General playing right now, is that the appropriate role for the Attorney General to be playing? Is that in accordance with the process required by law in Sierra Leone? That's my question. Is the Attorney General following the right steps, or has he skipped a lot of steps that he should, number one, should not be the one doing that, and number two, it should have been some committees set up by Parliament that should be doing that. Again, because it's a very confusing thing, because it's confusing in the sense that it seems to me the government is playing a dual role. The Attorney General is part of the executive branch. They are playing legislative role now. The executive branch is playing a legislative role. So I wonder if that can be done, and if that's consistent with the prescription set out by the Constitution or by Parliament. That's the main question, because I don't think so. So now that clarification, they will act, because it seems to me, like I said, the Attorney General is playing the dual role, both legislatively and executive-wise. I think that falls under the category of conflict of interest, and all then subsection laws then we break down to in different category, entrenched clauses and non-entrenched clauses them. All, there is no exception, if I understood you right, they should have been presented to Parliament together. Just, categorically different, but they should. None of them are exempt from circumventing Parliament. That I mean, you understand it. And in that sense, the law is being broken, and it appears as if we not get nobody takes this thing to court to try to challenge how the process is going, because already Parliament has met. I mean, and the cabinet has met, or the cabinet don't meet. Then just they go through the motion, like I say, and then go back. What them before don't do before. Now go to Parliament at the top of the cabinet, going back to Parliament and get Parliament for confirm, rubber stamp, whatever you may call it, something we cabinet do agree on that should have been reviewed by Parliament that has not been reviewed. Now they're going to Parliament for let Parliament review something that should have been reviewed or previewed, whichever way we look at. So this is my own comment in terms of how we not a follow process, because we own system, the Parliament itself, then they make laws, then they violate them. And when these things are taken back to Parliament, based upon the analysis by Mr. Mengot, it seems you question the issue of jurisdiction arises, meaning Parliament may not have a subject matter jurisdiction, and then the government itself may not even have what I consider to be jurisdiction of any type, whether in a personal jurisdiction, subject matter jurisdiction, I don't think, because there's a reason why rules are set. If rules have A, B, C, D, then somebody just think, or some authority just think, say, well, we're not going to follow B, we'll go start off with A, then we'll skip to D and left B and C. That law is not being followed, therefore it's illegal. Whatever comes out of it, or when that process is not being followed, not to follow the law, whatever comes out of it has to be illegal. So I just wonder how the opposition, they raise that issue there, how the civil society, they try to get injunction for prevent the implementation. Because if they don't hold the feet to the fire of the executive, then they just take more and more and more power where the constitution not give them and where the law not give them in any way, shape, or form. They just take them because they're not being challenged. So that's my own comment about that. Again, you can fine tune anything that I say that is not in conformity with what you say, Mr. Mengot.
Okay, sir. The thing where you talk is very important, because from the recommendation, members say, then they talk about having an act of parliament where deal with the youth same. Youth development plan. I mentioned Andy. That's a completely new act of parliament. We're going to make you give the youth them some kind of role, like a quota. And they say that they take the AU definition of youth, the African Union definition of youth. Now, anybody where age between 18 to 35. So 18 because now the age will allow you for vote. 35, you're not a big man now. You're not a youth again. So then get that law. Then, for me, my main concern, when you talk about this dual role of the Attorney General, you see, now we know they get institutions them for do the role supposed for do. And I tell you why I say so. Because we get na salon where there is responsibility for reform, we lost them. But then bring them in, then are the Law Reform Commission. Then get the Law Reform Commission, they say let them reform the Police Act. The Police Act of 1964. Because you get recommendations at this tripartite agreement about independence of the police, how for train them, how for give them resources, how for make them become neutral. So that aspect of the work, then get into the Law Reform Commission. Then when it comes to things to do with electoral management, we get, same like you said, we get so many of them completion. You get the Public Reform Commission as well, where they look at the other one and they. But under the Electoral Commission, the Law Reform Commission, 9 for be the overall body for look at anything we go deal with legal. And let me refer to people them. The Sierra Leone Reform Commission is supposed to be an independent statutory body established under the Law Reform Commission Act of 1994. The primary mandate of that Law Reform Commission did now for review, reform, and propose changes to Sierra Leone laws, ensuring they are relevant, just, and aligned with the country's social and economic needs. So what's the function? Now then they review law, now then they recommend for legal reforms, now then they do research and analysis on law. They also, now then they determine how then they collaborate. So let me forbid the number one agency, not the Attorney General's office. They also, then they therefore encourage public passion input in the law. Too many conflicting organizations in this whole process. And law taker, for instance, now, these 80 recommendations when they take go, in I say 40 of that, now laws the way in I don't draft. Right? Where are those laws then? Because the cabinet paper in the first place, what it's required to do, that white paper now for say, these are the recommendations, right? These are the institutions that are related that will do A, B, and C. Law reform. This is the timetable and timeline as to when we want to do it. This is how the public will participate. And also how the other political parties who are not part of the tripartite agreement, because we get more political parties where they'll affect them. For instance, what you know as a quote one of the recommendation where they very important within this law, this tripartite report. I will refer to some of these things. If we go to recommendation 65, no, recommendation 70. Not telling what that recommendation means because it's very important. Recommendation 70 will affect all the other political parties. Now, a very critical recommendation where then political parties and they should be involved in this whole process. It said the Political Parties Act to be amended to require that if a political party does not win any elected office at local or national level at 2 consecutive general elections, then the party will be deregistered. Right. What does that mean? It means a party elected party where if by what this recommendation say, they not been get any representative in 2018, then they not get any representative as a result of the 2023 election, which means they would be deregistered for the 2028. So this is a critical recommendation. How do we deal with that? So these are the issues I'm reading by picking out this recommendation. Over.
Okay.
So you then
there again. Okay, there again. And these are main points. Each time you say this something like this, Mr. Mengot, what I wonder about, does the Attorney General's office have somebody as informed as you, or even more than you, that is not giving cognizance to their information here? Because the little I know, and I always make a disclaimer, The little I know in legislation or drafting legislations in constitutional law is based upon what I studied. And in years of practice, some constitutional issues, as I learned it from experience and in a classroom in the United States. I am saying this because when you make a law, there has to be consideration of the necessity and the reasonableness of the law we want to try to implement. So, for example, this recommendation 70 way to talk will get to affect political parties, all political parties, but adversely affecting smaller political parties. Okay? Will not make sense to me based upon the little I know in constitutional law. And I'm pleading with then so-called younger brains, experts, people with the degrees them from all renowned universities where Sierra Leone say they get with the maybe at the ages office, at the system. Please come on board and try to answer some of them questions here for us. What is the reasonableness for come up with a legislation like recommendation 70, what that recommendation 70 is addressing? That a party will get 2 poor performances at elections should by law be abolished. What's the purpose? Any political party will make a performance that bad, they themselves will know to self-implode or do something. That's an absolute waste of time. That's as we have it now, other than political purpose for eliminate certain political parties that may have the soundest of ideas but don't have the pool, for get rid of them. And this seems to me is a devious way of trying to eliminate the small parties them and for APC and SLPP for us maintain dominance. When there's a large pool of us who still believe APC and SLPP, as I always say, they are 2 parties of the same coin. They think alike, they act alike, they not get no new ideas. So if you get a small political party who might have the best of ideas but don't have the number, now laws are being drafted for try for silence them because then the performance, maybe it could be as a result of lack of funding or sufficient funding. Then it will spread them view, their ideology out for people to understand that they are the best. So we are saying because of that, there should be laws which say they should be extinct or getting rid of. The question is, what's so reasonable about such a law? And what's the necessity of such a law? The party itself will self-implode if it cannot sustain itself. It's just like saying, is somebody so poor and able to feed himself? Government forget the power for just put unto death because, 2-3 times it is starved and, they almost get for go resuscitate them. We have to have what you call reasonableness attached to legislations. And in addition to that, we have to have a necessity. Too much time is being spent on then legislations there when not necessary at this point. We are acting as if we not do cramp all them recommendations, then things here where they affect their recommendations here, the country will come to an end. Now, there are 80 recommendations, for example. That's a lot. It should take years for us to be able to deal with them one by one by one. So when you hear the Attorney General they talk about, then they'll draft laws affecting as many as 40 of the recommendations suggested by the Tripartite Committee. You do wonder, or Commission, I'm sorry, you do wonder why would they want to deal with as many as 80 within such a short period of time? The recommendations are great, but we should meticulously, deliberately, deal with them so they will withstand the test of time. But that doesn't seem to be what the motivation is. The motivation is to get as many such recommendations dealt with, regardless of how much intellectual input was put into them, just on paper, for just say, well, would I do with recommendation A, B, C, D, without thinking of the long-term or even short-term effect on the country and the people. So some of these things I do not understand, and we say we get people who get a requisite education, qualification to deal with the issues here. So what will happen? We will keep complaining about the Constitution. It will be such a disservice to the country. If we amend the Constitution again, if we overhaul the Constitution again, and not deal with some of them subject matters there, with forethought, deliberation, and with some seriousness, we should put politics aside and try to create a legacy, because that's what will be good for the country. So this recommendation 70, I think is a major recommendation, because I've always questioned also, this is the reason why, because sometimes some of them questions here, only those in government and the political parties will be able. Maybe we'll need to start extending the invitation again, because some of them questions here, even the opposition should be able to answer them. For example, why is it a tripartite? Why not a quartet? Why not to 4 parties? Why 3? Now, if SFPP and Fearless So should be a party because they're in power, APC now the largest opposition party, then we get international observers, which makes sense for purposes of making sure that we don't waste time and try to go back and implementing the same old thing. But what about the smaller political parties that should have been? Because either APC should have been representing all the political parties with an agreement that all these parties are represented, or they should allow the smaller political parties, them as a group, they should come at one for form the quartet, meaning 4. But that's not what they're doing. And then the small party there, I don't see them raising any objection. What we can see clearly, you don't have to be a nuclear scientist, or a renowned scientist to see the purpose behind the way it is. Why APC alone? What about the smaller parties? Why haven't they come together and say, but what about us? This is the first time, again, Mr. Mengot, correct me if I'm wrong, in Parliament, the smaller parties are not represented. The previous times we will get representation by the smaller parties, them, 1 or 2 of them, it helped, not only helped, but it allowed us, the big party, them, for reach out to the smaller parties, them, for form a majority in government or in Parliament. Now they've rendered the smaller party, them, by operation of law, useless, and forcing them to disintegrate. Is that good for the country? That might be, I don't consider that being smart. I consider that being devious, cunning, and short-sighted, because it doesn't help the country at all. You take like Israel. The reason why you are able to practice their own democracy, because they allow smaller parties them for lean one way or the other to allow the larger parties them from form a government, but yet the smaller parties them for always in a position, if they withdraw, they can create an imbalance. But we are trying to make legislations now for reform of the electoral system by giving unreasonable and undue advantage of one party over the rest of the other parties then. So one could clearly see what is being done. And then, as if that wasn't bad enough, we start coming about sharing of power. I think that's a new invention in terms of the government in power wanting to share power. So how does the other party, when a part of the sharing with less membership, how do they become a majority if not agree? To me, it looked like a connivance for hold on to power indefinitely. So there are many criticisms I have of this system, of how things are going right now. We will not ever resolve the PR system, this section 38 and 38A. Then we're jumping all over the place trying to do so much when we not finish one thing. It's clear the PR system as it is now will be beneficial to the government in power. That's clear. But is that the long-lasting posture that we should take? Or should we continue to find what will be good for the country? You know, it is not in the best interest if one party is allowed to hold on to power for too long. You know, it's healthier when the country get parties, we get system in place where we can allow parties in and out. Because we see that it happen in different countries. We've seen Ghana in the past 20 years, how many governments they've changed democratically, by the way. I mean, that's what I wish for the country. Not a system whereby one government come, they manipulate the system to the advantage of one party and to the disadvantage or to the detriment of the rest of the country. Then we begin to wonder why are things not working out. So, and again, I think any kind of committee that we're going to form in terms of parliamentary democracy, we have to take into account what is good for the country. Because already the system is very flawed. We get the government as it is now. The Constitution say the president is a member of parliament. A phrase that I find so ridiculous is laughable. A president should not be a member of parliament in a democracy. Who came up with that idea there? Why they came up with that idea there? And, you know, what was the idea behind it? It's crazy. You just give a president the power. In fact, it contradicts the separation of government. It contradicts completely the separation of government. The president, who's head of the executive, is a member of parliament. And we get all them big stuff and big shot intellectuals here, and we think, say that made sense. Who came up with that idea? What constitutional expertise did he have, or did they have, to come up with that kind of a thing there? Then, as if that's not worse, the president get the power for make appointments in parliament, such as appointing the clerk of parliament. Where did they study government and constitution for reach that kind of a system there? So we undermine our own system. They are so contradictory to each other that it's not workable. We cannot even take one or two steps without falling face flat. And then, worst of all, legal system or lawyers are not trained in such a way as to keep going to court, raising constitutional issues, forcing the courts to make final decisions on some of them laws they are. None of that is being done, you know. So there's a lot. And again, I invite the professors then, waiting at Frabe College, on the law schools and where they teach constitutional law. I invite the Attorney General, with all due respect, for appear on the show and try to enlighten us where we are wrong or where they are wrong. I invite fellow lawyers to come to call in, join us, call in as guests. These guys you name, you know, just raise questions. Let's do it in the interest and for the good of the country. They'll put your ego aside. I stand to learn a lot. In fact, in the United States where I live, we get what you call continuing education for lawyers. I've been a lawyer 49 years. It will be 50 years next year. I'm still required to take continuing legal education as long as I am in practice. Now, Australia, where we going to get diploma, we don't learn all the book, we don't need any more book. You're not getting such thing. But there's a reason why the Americans and some other countries then get continuing legal education, continuing medical education, continuing accounting education for professionals who have major influence on the system, you know. But we believe, say, once you don't graduate, you don't learn all the book. But the reality is, in fact, I can show you where there are analysts who say everything you learned in university the past 4 years are now redundant and unnecessary. By the time you start university to the time when you finish, the world got changed so much that you need a lot of learning beyond that diploma what they give you. But we don't believe that. We believe, say, if we take that diploma, they begin to scare everybody. Oh, me not a constitutional lawyer. Oh, me not this and that. Well, for those of us who know better, it doesn't mean anything. You know, you're not a lawyer, you're not a doctor, you're not an engineer, only because, yes, you get the requisite intelligence and education for meet the minimum standard of your profession. Beyond that, now waiting you accomplish what you come up with, now go show how much you know and how much you don't know. So, but now I make with see things like the president is a member of parliament because until he gets somebody who not take constitutional law one day, then go put in a constitutional law committee for draft constitution. That's what you get. You know? So I hope I don't come across as being disrespectful or condescending. I don't mean any of that. But I'm just trying to bring this point up for say we need to get into the business of appointing people to the appropriate committees consistent with the qualification we then get, not to consistent with the diploma we then get. If I have a PhD in biology, it's okay to appoint me Minister of Finance, but I don't think I will be as useful, you know, as I would have been if you had appointed me to the environmental or some related or health ministry. So that's what I have. I got a lot more to say, but that's what I have to say. Mr. Mengo, then let me just comment about one thing. You talk about the GIWI Act. What is that?
The Gender and Women's Empowerment Act. We talk about that 30% quota. Okay. Yeah. For now, continue now. There is another controversial recommendation where I want to look into. Before now, I will say for close this segment of the conversation, look at what the Constitution say about how they amend the Constitution. Because I want to quote the Attorney General. So let's go to recommendation 65. This is very interesting. I know say it will make music to your ears. Recommendation 65. It says in penalties under section 132 and 160 of the Public Elections Act. I believe say there in section there are people that will violate the regulation. And then they relate to the misuse of state resources in campaigning, including disqualification of candidates who do not comply or whose supporters do not comply. Listen, misuse of state resources. So the candidate, okay, now, let me show this misuse of state resources. Not for this government alone. It has been forever. Ministers, top NGOs, parastatal heads, they are given official car and special number plates. Right? So, what in this they say, if that minister they use that card, when a state resources for go do political campaign, for even attend political rally, it's in violation of the act. If we then also the extend to even in supporters them, and it will lead to disqualification. Now go back. If you remember, before the lawyer come, the Electoral Commission, ECSL, now they determine who's take campaign period for start. That was what was happening. Now, the last election, 2023 election, we will see where they say the opposition offer begin campaign again. But remember, the president was a candidate in that election. He was going to be contesting again. But then he used his power as president, say that time they go meet the people tour. And when they go meet the people tour, technically he was campaigning. So is that not an abuse of privilege or even misuse of state resources? I know some people will jump up to me and say, oh, na president if for Duam. Okay, Lord left the president. When some of the ministers, the way they go, they go through their rallies and they use their connections. Is it not in violation of this particular thing where they put there? So who should monitor it? Who should determine it? How? The only way we can do that, now if somebody challenge them under the electoral laws, but how reliable with judiciary system is in terms of bringing that, I say that can lead to disqualification and dealing with the case on time, because there are also recommendation about in the Tripartite Report on the time it is taken to deal with then kind petitioner even before registration. So over to you, sir. How do you see this recommendation 65? If you want, I can read them.
No, I think I get the gist of it. Yeah,
I mean word by word.
Yeah, I get the gist of it. And recommendation 65, I solely agree with that. But again, this then here, I mean, these are wonderful recommendations. This is why I do not understand why the Attorney General is talking about, or the Chief Minister, then they talk, say, we don't get an answer for about 4 of the recommendations, of which 42. Nobody seems to know any of them. Yeah, go ahead.
No, they say 40 recommendations.
40, I didn't mean 4. 40. Yeah. Oh, yeah, I'm sorry, I meant 40. Yeah, 40 of the recommendations here. We not even know 4 of them. We don't even know 1 or 2 of them because everything is supposed to be secret. Now, this recommendation, this Public Elections Act, what we talk about, and this recommendation 65, it will be so healthy. If, in fact, what I am interested in, and Mr. Mengot might be able to answer, there are at least 80 recommendations or more. Where are we? Can we please know what they get on the books to take to Parliament? The first 10 recommendations. Can we know the response to the first 10 recommendations? And how much has the public been able to participate in it? And are those recommendations going to be presented to Parliament in accordance with the law? Don't forget about 40, just 10, the first 10. Because it seems to me every recommendation about the tripartite, if we follow them and try for amend, because watching the tripartite they talk about, they have looked into what could strengthen with Constitution for good. But it appears as if that's not how we're taking it. We're finding ways to circumvent the law. We're not going to do any good because it will come back for Huntry. Otherwise, my thing is, we could just simply ask the government for, please just even come on with show and do, let's go with the first 5 recommendations and how are they responding to it, and how does it, how is that progressive, how does it help the country? And even if it takes with the next 2 years, if we do it recommendation by recommendation, you know, there will be money, like money in the bank, because we don't go through that. We don't make the public participate. We don't put them through the parliamentary process, and even the civil rights groups then can challenge them. And Mr. Mengot say, even though I take the position that our courts are not strong enough, but that doesn't mean we should bypass them. It's better for them to go on record. I mean, that they take a position than to let them slide, not taking any position, which I think that will be the final arbiter of the law. And I always can say about Parliament, not all laws passed by Parliament are constitutional. Therefore, not all laws passed by Parliament are legal. But if we just not challenge some of them, Lord, and they become, I mean, I know we want, because if I say illegal laws, they are not laws. in technically speaking. So if we're not challenging some of them here because a parliament pass them, then it becomes the operative law for the country, and we're going to follow laws that are clearly on its face unconstitutional. So I'm requiring, or I'm asking that then so-called responsible bodies, and I encourage the lawyers then for start challenging some of their laws here, even criminal laws, acts that are being passed by parliament, challenge the constitutionality of those laws if they don't seem to be consistent with the prescription set by the Constitution. Don't say because a parliament passed them, therefore it becomes the law. Again, like I say, when they pass or propose and pass some kind of law recently about the national identification number and so on and so forth, there are lots of violation of with this communication and the cyber law. There are lots of things that they don't put in their laws, and they will infringe on the rights of people, free speech, or even the recent act by the police having the power for stop people and for talking about national issues such as Kush, or demonstrate, make a peaceful demonstration. The police doesn't seem to have the expertise to just monitor peaceful demonstration. It's so, I would just go by the flow. And who asked the police not to give permit to people then? We don't know. And if they have such a power, why will they have such a power? I was asking my co-host, Mr. Mengot, just the other day, say, why does the vice president and I think the Bar Association, I think they get, they are part of the committee of the internal security operation group or administration, because it looked like the law, because if you get the Bar Association in such a committee, they are the ones who should be there arguing for the abuse of rights of individuals. But when they don't become part of the group, the police really deprive people of their rights. Isn't that a conflict of interest of the Bar Association itself? Are they serving a useful purpose by being part of that group there? And I like to understand, why is the vice president head of the internal security unit when that wasn't the case in colonial?
The vice president is chairman of the police commission. The police commission, according to the constitution, and get the right for deal with the conduct of the police service, and even in terms of validating candidates for recommendation for the president for appoint an inspector general of police. But before we not go, one thing we ask, I want to deal with that, very important. Because I will not just blame, they say if you want to blame the dog, you can for blame the bone. I will blame the very parliamentarians themselves, judging by that video that we listen to waiting that member of parliament will say. It go back to this procedure, what you always talk, parliamentary procedure. Because the purpose of that white paper should have answered your question. Because the white paper then will say, okay, of all the 80 recommendations here, right, 40 deal with electoral management reform. This amount of recommendations will require amendment of acts of parliament, not the constitution, because they talk about amendment of the Police Act 1964. Then talk about bringing a new act for the youth, right? They talk about amendment of the Political Parties Registration Committee Council Act. Now they call it regulation. They talk about amendment of the ECSL, the mandate. So the white paper should have said, look, these are the 80 recommendations. Put them in a structure where say, for each of one, you compartmentalize them. The one that we need constitutional reform, Then they will need reviewing Act of Parliament, because Act of Parliament, some of them, if you review them, it will affect the Constitution. Because the Act of Parliament, like even the Political Reforms Act or all those things, they are a subsidiary act to the Constitution. So that is where we got it wrong. And then I'll go back to this recommendation 20, the Member of Parliament being quote. And then you don't need, now then self, because Parliament can make the rules. Because if we go to recommendation 20 again, now read them back for the purpose, that is where we had the mistake. Recommendation 20, it say, Parliament for create an oversight committee, representatives of all political parties. Now we get only two. Represented in as a standing committee on electoral matters to review an electoral cycle, inquire into electoral preparedness, and guide legislative reforms. So Parliament, in the first place, for don't set that committee there, and that committee there now, and then for even look at the government white paper, which show the roadmap as to ban laws and amend the constitutional law. But let's conclude by, let's go further and waiting the attorney say, which for me is a very dangerous precedent. And he go see say will not go Norway. The Attorney General in this consultation, what he said the thinking was to hold a number of consultation and civic education activities with various sectors of the public. Remember, for meet different people and present a referendum asking a single question requiring a simple yes or no answer about whether Sierra Leone wants the new constitution or not. So here now two they talk about now. Which in the Attorney General they tell me. So on one reform laws them, which will mean reform sections of the constitution. But then on the same hand, it tell we say we go need a new constitution. Who that go draft that constitution there? And how we go get the all thing ready in line with the recommendation where instead tell we say the president say all here for run done before this government come on power. That's an exercise in futility in my own view. Type the constitution for how you do there are provision in the constitution for how you do a referendum or amend constitution. That is section 108. You say first you can't forget a bill or an act of parliament, right? And that bill there, first, you can't forget the first reading of the bill in parliament. The text of the bill is published in at least 2 issues of the Gazette. What's in the first reading? For say, this, na so one do. Then you publish it in the Gazette. Provided that not less than 9 days shall elapse between the first publication of the bill, Gazette, and the second publication. So what it means, say, you can for them put in the Gazette for say, this bill, now they deal with the constitutional amendment. And then, chapter 3 of the Constitution is an entrenched clause. Then it gives the sections of the Constitution with an entrenched clause. 46, 50, a lot of them. So now look at, for the purpose of this, now look at what in chapter 3 of the Constitution say, when an entrenched clause where you cannot touch. Because it look like, say, there's a lot of things where we play, we joke with, you know. Part 3 of the Constitution, it deals with issues for do with democratic rights and all that. Okay, let's look at it. Section 3 of the Constitution. Okay, that chapter 3, now recognition and protection of fundamental human rights and freedom of the individual. Hello, look at section 15. It talk about things to do with life, liberty, security of person, the enjoyment of property and protection of the law, freedom of conscience, of expression and of assembly and association, respect for private and family life, and protection from deprivation of property without compensation. So you see, with all the what they show so is that there are so many things in the Constitution which we cannot touch but by a referendum, like freedom of association, right to property, right? So, whose magic the Attorney General want play for, on one hand, review certain constitution by constitutional instrument, then at the same time, it tell we say, we need a new constitution. We're going to require a referendum. And that referendum therefore include everything for the people for vote yes or no. Look at how many chapters in our constitution. Even the 80 recommendations self na the tripartite. Almost people they know about it. So that is my view on this subject. And if you want to follow up on what they say, then we can go to part 2, because we get another important issue will come up where nothing they for do their mining contracts, and the other thing them na the contract. So over to you, sir.
I think we should go to that, because the issue to deal with unconstitutional or tripartite recommendations here, they are so important, they are so necessary that it could take. In fact, we can do a show for 3 or 4 or 5 weekends. We're still not going to be able to address all the issues there. And unfortunately, people, it might be a boring subject or topic to people, but these are the same thing that comes back to haunt us. So these are things people have to pay close attention to, not for which state things get out of control, then we begin complaining about the government. Now the opportunity is there for us to raise concerns, for the raise, not to for just listen, or not to for just get more interest in gossip type of news, like a judge and a girl. Those are sensational issues, but they're not relevant to the country in terms of impact or making progress. You know, a judge get a side person. Yeah. I mean, much amount of part of we make up, we like forget a little bit of gossip news. It helps the soul a little bit, but those should not be the kind of thing, or those are the kind of things that we focus on a lot. And even on that topic, there are certain things, I hope they could make new laws with respect to that example you had to give. But so I think we can move to the other one, because the other topics are equally important, Mr. Mengot. So let's move to that. We hope we will come back to, from time to time, we will touch this tripartite recommendation, and probably in the process, we'll go wonder why the SLPP, APC, and the international observers, and what happened that the smaller parties, them, who once used to have representation in parliament, and even when they did not, they were allowed to exist. Why is legislation, are they going to comply with the recommendation? I think recommendation 65, rewrite that according to the prescription, I believe, of recommendation 65, we need for review them and find a reason why we for activate the participation if it's not already deactivated. Then participation, win or lose, let the political parties survive. We for pass laws for making them exist, we're not for pass law for making them extinct. So yes, sir, we can go to the next topic as far as I'm concerned.
And also, Lord, remind reviewers and say, we want in our views them, and I can still call in, the lines are open. And
Correct.
also, if you're unable to call, and I can still send in a comment through the various platforms, through with Facebook or YouTube platform, where we go address this issue. Because this is a thing where it affects all Sierra Leoneans, whether you're at home or you're in the diaspora. Because then changes here when they make, even in the electoral laws them, under the recommendations of the tripartite, then talk about diaspora involvement. So not to just anything for the politician. But now come to the second part of we.
Okay, there's a comment. DS television
Viewers have been calling, but not one is answering the phone. I want to make a contribution to this program.
So I hope the control room. I hope the control room will get that.
Control room, can you check if we have any calls?
And if we don't, there's indication that people are not able to come through.
I think let's repeat. No, let's repeat the WhatsApp number. So they not get the WhatsApp number. What's in the WhatsApp number again?
There you go.
Yeah, we WhatsApp number. Now +1. We can America register +1 343 997 5828 +1. Then a country code because in America, the WhatsApp number. But you can use them from any part in the world. 343 997 5828. So that person will say in a try for call. If you call that number there, we were ready for pick your call.
And Mr. Mengot, why don't you just suggest the other numbers than the one for listen to any other platform like YouTube, VOS? They'll just go through that. Probably I failed to mention that in the beginning.
Yeah, you can send message if you're able to call on the YouTube platform when a VOS television. You can still send message to a Facebook platform where you have VOS television. You can send message to X when I former Twitter instead of VOS television. If you use any of them methods here, you go able to get to it. Okay, there's somebody, if control room can display them, there's somebody where send a message. It says Salone is a failed state. All the politicians are opportunists and continue taking advantage of the ignorance of the majority. The APC and the SLPP have conspired to enslave the people and continue to deprive the citizens of their birthright. It seems we're heading for more tragedy and perpetual poverty. That is not the view of we are, although we don't say, we talk about the lackadaisic attitude or the connivance between the two political parties. But we are citizens. That is why we the do them here. Me and Mr. Shillon. Between us, Mr. Shillon, next year go make 50 years in the legal profession. Me, my own main profession are transport and governance. And next year, I go make me say 50 years in the transport profession. There's another one where say the government of Sierra Leone does not respect government has shown disregard for constitutionality. Yes, this is what we're saying. This same project where they do so, or this broadcast, will they show how they not follow waiting to happen. Because it's very politicians. Yes, somebody say actions such as halting palliatives align abuse of power to suspend elected officials are cited as the evidence of undermining the Constitution. This is all our concern. We thank you for that contribution. Now make sure we then have for showing the procedure and the process system where for go for let we do things right. I don't know if you want to say anything before we go back, Mr. Shillon.
No, sir.
We seem for don't read some of them comments here. Right? There's other one where they talk about evidence of abuse of power. It's always happening. We foretell God thank you, we country. We see say this election 2023 come, although we get draw, but we not resort to waiting to happen in other African countries like Cameroon and Tanzania now, and we pray say civil war, civil disobedience. We go continue for encounter, whether you be politician, you be student, you be youth, Because in their recommendation, he addressed everything. He addressed issues for deal with women them. He addressed issues for even disability. People there with disabled problem, how them for be participate. He addressed problem of youth. Law not just sit down, they talk about would have been do good, would have been do bad. Because on the one hand, we get propagandists and blood. Then we'll get the other hand, they will go say, oh, the other government be not do them before they do them. Not to that would they talk. Would they talk about how do we get things right? So if we not get anything, let me introduce the next subject where now for deal with this Octea Mining. Who then are Octea Mining? Octea Mining na a diamond company where now they get Koidu Holdings. Where we see small drug in there between them and the government. Where we get involvement of the chief minister. We get involvement of the first lady. We get involvement of the labor minister. And what's in this problem? Octea Mining that they operate in Sierra Leone. Beaucoup issue don't care about corporate accountability, labor rights, environmental sustainability. They talk about labor disputes, poor working condition, underemployment, and underpayment. They also talk about environmental concerns and how the company mining activity they deal with environmental degradation, pollution, water contamination, earth tremors. Then talk about community relation and legal dispute. So all them here, how will they arise? Now that worker look now because of the way we government they enter into agreements on them mining deals here and any other deal. So for start this, Lord just give a short clip where yourself now parliament they talk about them contract here. It's as if he's telling us that we are powerless. Is that the case? Control room just play that short 1 minute clip there for we.
The moment a political party is in governance, there are certain agreements they force you to accept. Because if you do not accept, they support the opposition against you. Our division is creating an avenue where people exploit us all over the place. They call themselves investors. Now we have powers. We have powers that will send companies. You are forced to take those companies to mine here, to do this, to do that. If you do not accept, then they walk behind the scene against you in support of the opposition. And you will not want that. So whatever they bring, you accept. Even very terrible agreements, you accept. There's no way around it. So until we resolve our governance system, we will not move forward.
Okay, sir. I'll let you start with this speaker in saying before we go into the actual details of this Octea Mining and the recent ruling by the appeal court judge. Over to you, sir. What do we speak up?
As you say, this problem where the speaker they talk about is across the board, is uniform. Whether an airport agreement, whether the water key agreement, whether a toll agreement, all the whether a mining agreement, the pattern is the same. They're not to deviate, they're not to change, because I know of there is no excuse if we are in control of our parliament, our executive, our courts. We cannot blame the parties of them still being at fault for holding us below international standard. That is show demonstrate with weakness. It is show we demonstrate with lack of preparedness. It is demonstrate we lack of willingness for faithful people and for improve the country. Because these people don't come and impose themselves on us. Regardless of what you say, no matter how unconscionable in law, mean an agreement the agreement is so one-sided that it's not based on reasoning. It's just based on peer power. Well, you will get unconscionable type of agreement if it was the other way around. Now I could see the companies them complaining of that because the power to be is in our hands. But now here we, the ones who have the power, we meaning the Sierra Leone government, is complaining that the others, these companies coming in, are somewhat putting them in a position where they get for a position of take it or leave it. This is what we, the company, foreign company, they suggest, they propose. When I take it or leave it, otherwise we'll go to the opposition way for make. But what point? I don't even see. It would be nice if the speaker can try for tell we how can the opposition be used against the government in power. Let's say a mining company comes in. They want to mine any of the minerals or an agricultural company or whatever. Then say, no matter what, we are going to get 90. Well, a good example is like the toll agreement or the airport agreement. And Mr. Mengot go even elaborate on that better than I can. Then come, then say, we go build, we go administer for 25 years. A toll booth, because of the road construction, will lead to and beyond that toll booth there. Okay, then say, but in exchange for that, we want 90% of the profit for the next 25 years. Okay, then the next 25 years, now we manage the progress, the process. We're not even say in conjunction with we or us. They're not to say that. They say now we demand it, now then we meaning them, the company, and then they manage the thing. They want for managing for 25 years. What is stopping us from making a projection as to the amount of course, before we even get into them, with them into an agreement, if we don't get a projection or feasibility studies, we will give you a projection of what income or amount will be derived from such an agreement on a daily or yearly basis before we are even agree on 25 or 30 years. So if they can recoup the investment in 10 years, why give them 15 extra years? And the agreement, if I recall, after the 25 years expires, it doesn't say anything about who will take over the operation of the project or the establishment. It looks like that is silent, that is vague, is subject to whatever comes on. So then we turn around and we're blaming the company. These companies that come in, they get a commercial purpose in mind, where any good business forget. You try to forget as much and hold on to as much as you can. If the other side is foolish enough to give you almost everything, why shouldn't you take it? So because they are for profit and business, they don't come for render charity. So if they go come and take with mineral resources, they run, they say we want 90%. Then after for 25 years, we'll not say, oh no, 25 years too much. It's 15. Should they be the one to suggest that to us? So I respectfully disagree with the speaker when he say then go to the other side. Because if they go to the opposition, the government in power can challenge the opposition and use that against them for say, well, you see, we take this position because we think this is what they're proposing to come for start operation of our country. They say they're not going to take care of the environment. They say they're not going to give workers in good working condition. They say they're going to engage in unfair labor practices. then say they will contaminate with water, then or they not do anything about water contamination or not to contaminate with water them. Then say they're not going to create, they're going to try to minimize dust pollution. What we require all entity and they vex. They go to the opposition. The opposition say, "Will come." Why should the government in power not be able to articulate that to its people? It's such a strong case. So why should the fear of not agreeing with a company that want to do business in Sierra Leone be the motivation for accepting any kind of deal? Because the speaker is saying, we are forced to. No, we're not forced to. I don't see how the government should be so weak as not to make a favorable case, a convincing case, a persuasive case against the opposition. In fact, I take the position that with a responsible government, a company wouldn't dare because the opposition wouldn't have anything to offer them. And if the opposition tries, when you demand reasonable benefit for your people, the opposition will be doing themselves a disservice because we not make una case the opposition. Now, if the opposition is able to go into the opposition is not the issue, because if they are able to go to the opposition and the opposition saying, well, then they demand 10% from now, 15% of net profit, but we will take no less than 20. Why will that work against the government when the government is demanding a high? So the only reason, the fear of going to the opposition, because if we do not agree at anything proposed by a company, would be a basis for just agree to anything. I think it's poorly grounded. I don't think it's persuasive at all. So I think the speaker gave to be very careful how they come up with anything here, which he say, because that to me imply poor representation and poor protection of the wealth of a country. And in addition, from my position of view, the speaker for be a like a referee, not to for be a mouthpiece. I understand he was a member of the ruling party, but in role not different. The speaker in role as a speaker of parliament changes. It's like a lawyer who was, let me say, working at the Attorney General's office. Then they appoint him as a judge. In the Attorney General's office, he was pro-government, pro-executive, a mouthpiece for the executive. But once you become a judge, your role changes. You can't continue talking as if you are a prosecutor at the AG's office. So I think the speaker should be mindful. Let him do not become the spokesperson for the government. Let them make their own case. Just play the role of a referee, and try to call the shots as you see it. That is all. And that takes me to the previous system that we had, but it is what it is. Let me take a call, then I'll go pass it over to me co-host. Hello, caller. What's your name? Where you call from?
Yes, sir. Good evening from your side. For the call.
Welcome, Mr. Yes, sir. Welcome.
Last week when I see no call, I was still listen. Not the thing, I noticed my talk. Yeah. The last thing that way you talk about, where the speaker they talk, I don't let anybody pay attention to that because they just try to tell you, say, now because government not get any share or any contribution when it will give towards any mining activity, makes anybody will come, no matter how bad is, they say for foreign investment, then they take them. So that they will begin to make Allah say, oh, investors they don't come. That has been happening for a long time, not to today no more. In the talk, I don't make them define excuses, because now the first thing the enforcement been talking this what they are. But as you know, then it behave like a court where somebody don't talk something, all man they talk them. So this lack of where this money makes it powerless, Guinea, neighboring Guinea, now they sign contract them. We give them 15% immediately and give them the option for get 30% in less than 10 years. And now because the Guinean government get money for put the, but if you can't get an economy, we till this time, now November they come to, most of the MDs they don't get a penny for this year. Now money no day. So you not listen to that money. The main thing why I want put contribution to now for the constitution when I talk about, where when I think talk about the role of the Attorney General. In 2015, where they make that review of the Constitution, I know in 2017 and then done ABC rejects, where ABC rejects most of the thing them. Then the SL people now they may talk, oh, they not do this. They have been in power for almost 8 years now. Then they don't reject all of those where APC rejects. Because normally this thing for just don't be where they don't go through the reforms the way the post we didn't get the job, the cow them, now for let they adopt that constitution there. But now because the government always want to be comfortable, including the past government, so how they go give away the powers of the president? Because now they the thing they all within they talk about this about tripartite, this and I centered around election, so not to the powers of the president. When I did the problem they we make say the judge know the work, police know the work, the ACC know the work. They don't want to touch about all those. They don't want to touch on them. Then just they focus on election power. We want consolidate power. So in this is what I try for talking now. Not to the rule of the Attorney General for come tell we what you for take, what you not for take. But now because politics concern anything we salon they do, we salon we do. Now he make the government they take a role through the Attorney General where they surpass within Parliament for don't do in the play now the role of the Parliament and do now because they all get for listen to one man when are the president. Within the president one tender, and anyone puts in. Even the Supreme Executive Authority where an Escobar be rejected, they reject them. All of the things the one the Supreme rejects, they instead then come with other things then. Oh, would you agree election on the fixed dates? Or 50+1, PR, all about election. Nothing, not the way you talk about the fundamental rights of people, or the powers of the president, or talking about autonomy of the regions, or for give power to another call herself. They call themselves the vice presidency in so when they give powers to the region them or council them, not only powers, they give the financing way for run those because inside abroad now they call council now in the channel development, main development of the region now the council them. But them no one do them. Everything for come out from State House. So now this thing I want to put to the table say we are not going to get anything better from this review. Like Mr. Shilon talk, we will not review this year. We will ask again. They don't review the constitution because the same thing they will continue for to happen in the country. Because the way they make strategy now just different small from one party state, and them now they will make maybe a little bit different. So now that's one thing. So thank you very much, Mr. Man.
Thank you so much, Mr. Mustafa. Mr. Mengot, to you, sir.
Yes. Now, so one thing I was saying, commenting on what the speaker say, he said they go to the opposition. You know, clearly tell me waiting at the opposition. Waiting me discern from that is to say, when they come, agree for waiting they want, then go and use the opposition, empower them for undermine the government.
How?
That might be implied.
Yeah.
Yeah.
How? Yeah.
That is what he didn't say. But now, the key question is, as you can always say, we just continue to make laws, them pile one law against the other, attack and at times they don't make sense. Why do I say that? Because we get the original law we get in a salon, we get the Investment Promotion Act of 2004, whereby the legal for foreign in Sierra Leone. And then certain industry and they where it will be under statutory ownership. In other words, some area and they will not allow foreign investment. We've been in their wise, then create what they call the National Investment Board, a new organization. Where now, if you look at what they say, when somebody count investment, now the National Investment Board, now the relevant agency for review, for make sure say it meets the necessary proposal, a requirement. And propose, and bearing in mind the chairman of that body and the president. And go approve them and the investor can proceed with the project. It was only when they cannot sign the agreement here that actually they can go parliament now for ratification. And we'll look at the quality of the parliamentarians, especially this current parliament, where most of them come on the PR system. They don't get the technical knowledge, scrutinize some of the agreements here. It should have been the other way around. When such an agreement come or such a deal come, let it go to Parliament. Parliament review them, give the before it is signed. But what would they do now? They call in law after the fact. You know, lawyers are. Go tell me, I agree, then they go to Parliament for rubber stamp. And Parliament, they take time for look at these things with the way they approve investment. So even when you take the bodies, we get Sierra Leone Import and Export Promotion Agency, Slipper. Now you can't get National Investment Board. And Slipper still exists. Sierra Leone Import and Export Promotion Board, Agency, Slipper. We got the one, we get Sierra Leone Chamber of Commerce and Industry. All one in the day. Where mostly their deals here, they can go through, they don't sign them, then they can go ratify in the Parliament. And even when we sign the agreement here, if Parliament approve, according to parliamentary regulation, they should keep constant watch over the implementation of that bill. So we bring us to this Octea Mining. This is a Octea Mining, now they are the parent body for
Koidu Holding.
Or Koidu Holdings, when are the diamond people then. So what's in the problem? Then get labor disputes, conditions of service, whether in a Ministry of Employment they deal with them. Environmental concerns, when are the EPA, Environmental Protection Agency, where because if you want to do any of the activities that may will affect their environment, you can forget what we call EIA, Environmental Impact Assessment. And then on the different things then they talk about community relations. Octea Mining, they don't accuse them, say their social responsibility, they don't fail for provide adequate compensation and health care. So this dispute been in at court, Supreme Court make a ruling, then we get the appeal court. The people that will take Octea Mining go court, they get a right, which in a call in law, local standard. They get a right under that. So there was a press conference where they say the Network Movement for Justice and Development, where they advocate for community alternative, then go to courts, that the Court of Appeal of Sierra Leone overturned the High Court's then dismissal of a landmark case against Octea Mining. The ruling, they restored the rights of the Kono resident to sue for environmental damage, property loss, and human rights violation caused by mining activity. The court also said the residents then talk about customary lands and then for take legal action, even though the land the chief then get it because we're not scrutinizing lawyer. We get disputes, industrial disputes. Now, they say, okay, law go to court. Court don't make a ruling. This is the problem we will continue to get because we know the scrutinizing agreement here in the interest of the people. For instance, during the president's speech, he said last year, the mining sector, right, account for 1.2 billion of we export. But not to get out of that 1.2 billion, might give $6.5 million for community help. Then the government's own tax will get. You know, reach even 1/10 or 10%, because if you take 10% of 1.2 billion, now 120 million.
Correct.
So the tax will not even get 120 million. So why do we continue to make the agreement? That is the key question. Because we always get in dispute here. And because of it, that the rogue investors them, now in the Canada country.
Precisely.
So over to you, sir. What you say about this deal? Because the appeals court overturned a high court decision.
Okay.
Yeah.
Well, I think me and you will get earlier discussion on the hierarchy of the courts, but I think the losing side get one more court to go to when at the Supreme Court. They can appeal the High Court's decision, and normally in civil activities or civil trials, this also give opportunity where you have a balanced system where both sides of the issue stand to lose without compromise, because the Court of Appeals, the losing side when a Koidu holding or when a Octea, then can appeal. And as a result of that, then can use that appellate process there for work out a compromise, and thereby withdrawing the appeal if a reasonable or satisfactory agreement is reached. So the Supreme Court doesn't have to rule on it. So that will be, the status quo will be as it is based on how the Court of Appeals has ruled. Or they can push, the losing side can push for a definitive ruling on the issue by appealing to the Supreme Court. Now, I think earlier me and you discussed, I just went for purposes of the court, because I'm looking at it here, I'm looking at the hierarchy of the courts. The High Court is, okay, you start off with the Magistrate Court. Next higher court is the High Court. The next court above the High Court is the Court of Appeals. Then the final arbiter of whatever the issue is the Supreme Court. So you get the Supreme Court as the top, you get the Court of Appeals, and second, when the second highest court, then you get the High Court. Now, I think some of them disputes here, the matter of boundaries between chiefdoms, and issues apparently of like labor dispute. I think in general, the High Court seems to have original jurisdiction. They're going to magistrate court for them. That seems to be, again, the lawyers can call and say that's not right, but then of course the losing side from the High Court can go to the Court of Appeals because the whole essence of civil practice is for every time from the moment a lawsuit is filed, it gives an opportunity to start negotiating and try compromising in position, because you try for the court not to make definitive judgment, because that becomes the law. I mean, because the law, some of the nuances where the legislation are addressed, the court deals with all of that, will become the law. So when I get several opportunity from the inception of the case to be negotiated, because the moving side or both sides can always go back to court and tell the court, say, we've reached a compromise with, would they take a dismissal? The plaintiff can always take a dismissal. I think procedurally, that's the way it works. Now, I don't know how civil procedure is taught and practiced in Sierra Leone, but I think that's how it's done. So now, Koidu Holding or Octea, I think that's the name, they could, Octea Mining, when are the parent company of Koidu Holdings, then get one more step for appeal. If they cannot, but during the process, both sides should be at work trying to deal with the issues for which lawsuits have been filed. Whether, I don't know where the Court of Appeals, I don't know the detail of the decision in terms of whether Koidu Holding is held responsible for creating poor working condition, whether they're being held responsible for unfair labor practices, whether they are being held responsible for underpayment or underpaying the workers, whether they're being responsible for contributing to environmental pollution, contamination of water and contributing dust. I don't know the detail in other words, the findings of the holding. So that I don't have, but I would think that both sides will be served if we can. And even when they talk about mediation, I think there was a point that we're talking about mediation. The process of mediating, not everybody can just jump in and try to be a mediator. It should be certified, somebody certified in mediation that understands the nuances and of the dispute or the grievance. But again, this is what we have. And I mentioned in all the court system, because, sometimes Mr. Mengot is my guide, but I'm almost certain that the Koidu Holdings get one more step for go if they are discontent or dissatisfied with the outcome of that decision there. When at the Supreme Court, long time ago, historically, before we became a constitutional government or republic under the old common law practice, with Supreme Court was the court of original jurisdiction, which is now called High Court. And then the Court of Appeals was with final court. Then there was one more court above the Court of Appeals, which was that was in England, the Privy Council. So we also had a court higher than the Court of Appeals in Sierra Leone. That was the Privy Council, which was in England. That's where cases were sent. If you're not satisfied with the content or the decision of the Court of Appeals, to the Privy Council, and those cases were being argued in England. But when we had our independence, they stopped being the practice. We established the Supreme Court because the Supreme Court, by implication, means supreme, finality. So that's where we are. So I'm not suggesting anything. I'm just trying to inform the public where the dispute is and how they can be resolved. But Mr. Mengo, you have a right, or you can disagree with anything in this respect, because I always value your contribution.
No, you're right, because if you look at the Constitution, that's the hierarchy of the courts.
Okay.
Because it starts with the High Court, and then the Appeals Court, and then the Supreme Court. Because the Supreme Court is similar to this. We had the House of Lords was the final arbiter
Correct.
But then self do an amendment where now later on England self can get a Supreme Court
Precisely.
for replace the House of Lords. But anyway, I think say we don't go through with 2 hours, although we start late. And
But we've done
we
2
are
hours.
here now. We don't do 2 hours. And just for telling in advance, say my learned friend, because we get that title there.
Now,
Would be
I would suggest.
for
Okay, yeah, go ahead.
I'm sure you don't give me notice. Say the next 2 weeks, the next 2 programs, because of course, then say I remember at one time in there. Where I see one advert in Kenya where I worked, where you get the cheetah, which is the fastest animal on the world. It lay done before this safari lodge, and then say even the fastest. I think say Mr. Shillon, we owe him this responsibility for letting take a rest. So next week I will be here dealing with issue to do with disaster. And as I see today, I'm done in my Jamaican colors in solidarity with the Jamaican people for this disaster we didn't get. And they don't plan for the disaster. They may take an insurance policy after Hurricane Katrina, where means they may learn from the last lesson, where now then they pay them about 11 billion for recover the economy. So next week, we'll get a special program on disasters in Sierra Leone, and for them, your area, when I transport, because the 5th of November could make 4 years since the Wellington fire disaster. And the president get a task force, make some proclamation. So I would like for examine. Unfortunately, road accident is continuing in a larger scale to the ordinary person. My school, St. Edward's School, we lost with junior principal to a road accident. We learned to rest this week. And I think say Cambia herself also lost the principal to a road accident. We get a member of parliament who self died to road accident. So now, next week I go there here for talk about this issue of road accident, especially when they get its new year, they come, end of year, in and the diaspora, and I get for go home. The risk involved. So now I go left from here and say Tata and give my co-host the last word for say goodbye until they come back. We will continue this program.
Yeah.
And I stay blessed.
Okay.
Yeah, go ahead, sir.
No, I was just going to say, if I may, I thought it was my turn. But finish so because I just went for.
No, it's your turn. I'll finish. I've said goodbye to my listeners. Hope to be back next week.
Okay. Now, I was just going to add the fact that we did not talk about Kush, which I know is on everybody's mind, doesn't mean we're not interested or we didn't consider it a topic to be discussed. But these discussions, then we'll get today in a continuation of what we had done last week. And we'll figure say it's important enough, particularly where the Attorney General, they come try for push this thing to the point of making it become law. We just want to alert the public, let them follow up. But Kush is very important. We will deal with it. And so when I just look forward to the next couple of weeks, we will deal with the Kush issue, but we'll consider it. The fact that we'll not talk about that doesn't mean it's not important, because we see how it devastates with communities. So until then, thank you for listening. Thank you for your contribution. And we hope we go Yeri. We serve again next week. And if we get any idea, come up with it. Be prepared to send on a comment. And we go do, as always, try to answer it the best way we can. Until then, good night. And have a nice new week. Thank you very much.